Hello friends, welcome you all to my YouTube channel, that is Discourse on Law and Politics. In today's video, we are going to discuss about the UPAPO Prelims examination question paper of 2006. So as we had discussed in the previous video that we had covered the prelims questions of the UPAPO of 2002 year. Now in this video, we are going to cover the 2006 questions, 2006 years questions here, and we are not going to solve the question of the general GK here. We will only focus mainly for the law subjects here. So you all know that there are four subjects which are coming in the law category, that is the Indian Penal Code, CRPC, then the Police Act, and then at the last that is the Indian Evidence Act. So we are going to cover those questions. As you all know that in the UPAPO prelims examination, there would be total number of the question would be the 150 questions, and out of 150 questions there would be 50 questions for the GK, and the rest of the question, that means 100 question, would be from the IPC, CRPC, and the Police Act, and then the Indian Evidence Act here. So we are going to solve the questions here for the CRPC. We will start here from the Indian Penal Code, and then we will go for the CRPC, then Police Act, and then at the last we will take the question from the Indian Evidence Act and few of the questions at the last of the Indian Penal Code as well. So just stay tuned with this video and watch the entire video, because it would be very much helpful for you during the preparation of the revision of the UPAPO, and as well as for the preparation of the UPAPO prelims examination, because the examination is very close. So you can do a kind of a revision with the help of this video while doing traveling, or if you are not with your books or like that, then you at least can do a revision here. So just watch the entire video here. Let's start the questions of the law from the Indian Penal Code, and then we will take the questions from the CRPC and the Police Act, and then at the last the Indian Evidence Act. Prelims examination of 2002 from the law, and that is from the particularly from the IPC. It was a question this: A in good faith accuses Z B before a magistrate. So A is accusing Z before a magistrate in good faith. So whether A has committed any crime, so because he is doing things in the good faith, therefore A is not going to commit any kind of offense. So for this you can refer the section 499 of the IPC, because everything which is happening here, it is happening in the good faith. So accusation which is going to take place, that is in the good faith here. The other question which had been asked in the UPAPO 2006, that is the disclosure of the identity of victim of a rape is punishable under which section of the IPC. This is one of the most popular question of the UPAPO prelims as well as the UPPCSJ as well, and the right answer is section 228A. So if someone is disclosing the identity of the victim of the rape, then in that case he will be liable under section 228 of the Indian Penal Code here. Another question: which one of the following is an illustration of criminal attempt? So which is a question, it is about the illustration about the criminal attempt, and the options which are given here: A tries to kill B by witchcraft, A goes to Mumbai to buy dye to make counterfeit currency notes, A intending to kill B fires at B's coat hanging in his room, treating it B, A takes away his own umbrella thinking it to be someone else. So there are these four options are given here, and the answer is here, that is about the criminal intent, that A intending to kill B fires at B's coat hanging in his room. So because he was thinking that this is a B is there, therefore this is the case of a criminal attempt here. The next question is here, that is the in which case the Supreme Court had said that death sentence should be awarded only in the case of rarest of the rare case. It is also very popular questions for the prelims in the UPPCSJ as well as in other judicial services of the other states as well as the APO, and the answer is here, that is the Bachchan Singh versus State of Punjab. In the case of Bachchan Singh versus State of Punjab, the Supreme Court had said that the death penalty should be given only in the case of the rarest of the rare case. The next question which is here, that is right to live with human dignity does not include right to terminate natural life. That was held in which case? So You all know that the answer to this question, because it is one of the very popular question, not in the IPC only, but also in the constitutional law. And the right answer is Gyan Kaur versus State of Punjab. So in this case, the Supreme Court says that the right to take to give up the right is does not a part of right to of a human dignity. The another question which had been asked in the 2006, that is use of violence by a member of an assembly of 5 or more persons in furtherance of common object will constitute the offense of. The answers which are given, the options which are given here, that is unlawful assembly, assault, affray, rioting. So it is about the 5 and more people. If you just go to this, you can see it is about the 5 and more people, and also there's a use of violence. So in all these options, the right answer is the rioting. And the section 146 of the Indian Penal Code talks about the rioting here. So this is the right answer here. The next question which had been asked, that is the culpable homicide is not murder if it is committed. And now the options which are given here, that is the when the offender is acting in anger. The second option is that when the offender is acting under the spell of madness, when the consent of the victim who has completed the age of 18 years, or with the consent of the victim has completed the age of completed 12 years of age. So if you just go to this, the options which are given here, the right answer which is here, that is with the consent of the victim who has completed the year of 18. So that is the right answer here. So in this case, culpable homicide is not going to be a murder. And next question which had been asked in the UPAPO 2006, that is an employer deducts a certain percentage from the salary of his employees, telling that it is their contribution to the provident fund, but fails to credit it in the fund. Employer commits what kind of the offenses he has committed. And the options which are given here, it is about the criminal misappropriation, criminal breach of trust, theft, and cheating. You all know that this would be a case of the criminal breach of trust, because the money was entrusted to him and now he was liable to pay or contribute to the provident fund of the employer, but he could not then do that. Therefore, in that case, this would be a case of criminal breach of trust here. The next question which had been asked in the UPAPO 2006, and the question is here, under section 498A of the IPC, cruelty includes whether physical cruelty only, mental cruelty only, harassment of the women, cruelty by the wife, and that is about the harassment of the women, because it covers all types of the cruelty here. The next question which had been asked, and that is the question here is, A was on his journey by car from Delhi to Agra. B met him in the way and requested for a lift up to Mathura, or an intermediate town. A accepted to this request, but on reaching Mathura, Mathura did not drop B there in spite of his repeated request. B was carried over to Agra against his wishes. So what kind of the offense he has committed here? The options which are given here, you all can see here. These are the options which are given here. A is not guilty of an offense. A is guilty of offense of abduction. A is guilty of offense of wrongful confinement. A is guilty of using criminal force. So of course, it is a case of wrongful confinement, because he was not dropping B on at Mathura, and therefore that means he is confining that person. The next question is, which had been asked, a school teacher for the purposes of enforcing discipline inflicts moderate punishment upon a pupil aged about 11 years. In this case, whether he will be liable for any offense, the options which are given here, A is entitled to claim defense under section 89 of the IPC. A is guilty of causing simple hurt. A is guilty of causing using criminal force. A is entitled to claim defense under section 88 of the IPC. So what kind of defense he may take place, because he's a school teacher and now he wants to enforce certain discipline, and for that he has used the moderate punishment, and therefore he can take a benefit under section 89 of the IPC, and he can defend himself that it was done for his benefit. So therefore what you will see here, that in this case the teacher is not liable here, because it is for good faith and the amount of force was only about a moderate one. The another question which had been asked in the UPAPO 2006, that is illegal marriage with B was performed by a priest P, knowing that the marriage was illegal because A was already married. So the priest was already knowing this fact that the A is already a married person. Now A's father C and two other person D and N were present at the time of marriage. So what will happen now? This kind of the things happen during the marriage sometimes when all the people who are coming from the side of the no the groom. Then in that case, what will happen? So whether in that case C, D, and N are liable for abatement, only A's father C is liable for abatement, or the other question is that C, D, N, and priest P all are guilty of abatement. So, and the last one is only the priest Y is liable for abating the offenses. So, what you can see in this case, all the peoples they were knowing this fact that A is a person who is already a married one. So, both all these people, that means including priest C, D, and N, also they all will be guilty for abatement because they all know that the A is already a married one. So that is the case. That is the kind of incidents you might have heard sometimes in your life or on the newspaper as well. In the newspaper as well. Now, move to the next question. Which one of the following combination is correctly matched? So the cases are given, and then the important provisions are given to these kind of the cases. The first case is that is the KM Nanavati versus state of Maharashtra, and the grave and sudden provocations, state of Himachal Pradesh versus Asharam, that is about the rape. Karan Singh versus state of UP, right of private defense. Harjit Singh versus state of Punjab, that is a dowry that. So we need to give the answer with the help of the code, that which codes are the correct one. And if you go to this, the A is the correct one, that is KM Nanavati. You all know that it is a very popular case in India, and then you all have heard there is also a movie on this one, and this is the case which belongs to grave and sudden provocations. The second is state of Himachal Pradesh versus Asharam. Yes, of course, this case also belongs to rape. And the third one is that is Karan Singh versus state of UP. It is not the right options. It is not the correct. And the Harjit Singh versus state of Punjab, it is the right answer. So the options which are given like 1, 2, and 4, that is D option, that is the correct answer here. Now move to the 65, the question number 65, which had been asked here. The punishment for general form of public nuisance is provided in which section of the IPC? So if you go to this, you will see that the options which are given here, section 268, 269, and then section 290 of the IPC, section 291, and the right answer is here, that is section 290 of the IPC. Next, move to the next question here, that is the on account of an agitation, the lawyer ceased to participate in court proceedings and restored to Satyagraha. An editorial in a newspaper criticized as to whether it behaves to the lawyers as a clause to restore to strike. The lawyers were inter alia described as Kajia Dalal. So that means Kajia Dalal they have discussed, that means dispute broker in the editorial. So what kind of things will happen here? So options which are given here, editor of the newspaper is guilty of offense of defamation, editor of the newspaper is not guilty of offense of defamation, or the next option which is given here, let's see, that is not only editor but chairman of board of director and general manager are also guilty of defamation, and the last is that is none of the above. Yes, right answer is none of the above, because it is not any individual lawyer, it is only in a journal about the law, in general category of the lawyer. That means it was addressed to all lawyers. It was not very specific, it was a kind of a very general comment. There was no any specific comment was there. The next question which had been asked from the IPC year in 2006, that is according to McNaughton rules, legal assent is quite different from medical insanity. It relates to and the options which are given here, that total loss of cognitive faculties, total loss of cognitive faculties, and congenital insanity, and last is the none of the above. Yes, it is about the cognitive faculties. That means the accused person is not able to understand about the nature of the act, and therefore this is the right answer. come to the next question, which is here, that is the for the defense of mistake of fact under the Indian Penal Code. What are the options given? That is, actual mistake is sufficient. The act must be a reasonable one. The act must be a reasonable as well as committed in good faith. And last is that is the none of the above is correct. So if you are taking a defense of mistake of fact, then of course there must be a reasonable as well as the act must be done in the good faith. Then you will be able to get the defense of the mistake of fact here. The other question which had been asked, in which of the following cases the Supreme Court has observed that there is no right of private defense against the right of private defense? And the options which are given here, like the state of Punjab versus Sohan Singh, Surjit Singh versus state of Punjab, state of UP versus Ram Sarup, and then the last option, that is MR Singh versus state of Gujarat, and the right answer is state of UP versus Ram Sarup. This is the right answer. Another question which had been asked from the IPC here, that the mens rea required under section 299 of the Indian Penal Code is, it is intention or knowledge, intention or negligence, intention or recklessness, negligence or malice. So the right answer is here, that is the intention or knowledge. So that is the important for mens rea under section 299 of the IPC here. When two or more persons agree to do or cause to be done an illegal act or an act which is not illegal, by illegal means such an agreement is. So if someone is more than two persons are indulged in any kind of illegal action by the illegal means also, even that is a right cause, then in that case these all people will be come under the category of criminal conspiracy. There is some problem with this scanning here, but it is about the criminal conspiracy. Please just take care, that is about the criminal conspiracy. And now the another question which had been asked from the Indian Penal Code, that is, A incites his dog to spring upon B without B's consent. So whether what kind of the offenses A has committed here. So sometimes you see this kind of incident took place in the street, and now in that case A is guilty of criminal force. So that is the no right answer here. So these are the questions which had been asked in the 2006. Later on, there are some certain other questions which had been asked from the Indian Penal Code, which we will cover at the last part of this video. And now we are moving towards the questions from the here, from the CRPC here. So let's start to the questions of the CRPC here, and one by one we will discuss here. So the first question from the CRPC is here, that is the under section 308 of CRPC, an accomplice who does not comply with the conditions of pardon may be prosecuted and tried separately for the offense of giving false evidence, but with the sanction of, and the options which are given here, that is session courts, high court, state government, chief justice of the high court. So let's see what would be the right answer here. And yes, the answer is under section 308 of the CRPC, that is the high court here. Now another question from CRPC, under section 77 of the CRPC, a warrant of arrest may be executed where? So the warrant of arrest can be executed at any place in India. It is not to be specific to any particular state or any particular jurisdiction of the court here. The next question, that is from the CRPC again, under which provision of CRPC on receipt of FIR for the commission of an offence, the officer in charge of the police station will send the copy of the concerned magistrate. So here the option is here, that is under section 157 of the CRPC, the officer in charge of police station, he will send the copy to the concerned magistrate here. The another question which is from this CRPC is here, that is non-cognizable offences means an offence wherein the options which are given here, a police officer cannot arrest without warrant. The other option is, that is, the police officer can arrest at his discretion. A police officer has authority to arrest without warrant. On request of complaint, arrest can be made. So this is about the non-cognizable offense. Then in that case, a police officer cannot arrest someone without the arrest. So this is a kind of the offense of non-cognizable, and non-cognizable is not as serious as it is a case of the cognizable offenses. The next question which had been asked from the CRPC, whether any criminal court can impound a document produced before it. Whether that can be done? Yes, it can be done that the criminal court can impound a document produced before it. The next question which had been asked, that is, can a magistrate order the search of any place in his presence for the search of which he is empowered to issue a search warrant? Yes, he can do under the section 103 of the CRPC. So what you see, so yes, magistrate can do so under the section 103 of the CRPC. Now the another question which is from CRPC, summon case means. So what is the definition of the summon case which has been discussed in section 2W? My dear friends, please note sometimes in UP judiciary and in some other states as well as in the UPAPO or in any other state for the public prosecution examinations, they are asking about the question that in which section of the CRPC there is a provision for the summons cases. So section 2W is here, and the right answer of this one, that what is the meaning of the summon cases? Yes, a case which is not a warrant case. So of course, a warrant case is which kind of cases where the more than 2 years of the imprisonment is there. Then in that case, it would be a case of warrant case. The next question which had been asked here, that is, which one of the following cases is related to the defective investigations. So in which of the cases the court has discussed about the defective investigations, and the options which are given here: DK Basu versus state of West Bengal, Jahira Sheikh versus state of Gujarat, Sakshi versus Union of India, Dipesh Chandok versus Union of India, and the right answer is Jahira Sheikh versus state of Gujarat. So that is the case where the defective investigation has been discussed by the court. The next question which had been asked in the UPAPO 2006 prelims examination of APO, and that is the which of the following statement is not correct with reference to section 125 of the CRPC. My dear friend, just note this last question paper which when we had discussed, that is of the 2002, there was also another question from the section 125 of the CRPC. So this is a section which you need to focus more and more so that you could not miss any question from this section 125 of the CRPC. So the right answer which is here with respect to section 81, that is the obligation to maintain a married daughter whose husband is unemployed is of the father of such daughter. So this is a kind of the is not correct. Once a daughter has been married, and even though in that case the husband is unemployed, then in that case the father has no any such obligation for the maintenance here. The other question which had been asked, when a case is instituted under section 199 clause 2 of the CRPC, the procedure of trial adopted in such a case is, so which kind of the procedure is going to be adopted here? And the answer is here, that is a session trial. In session trial, this kind of the procedure would happen. The other question from the CRPC again here, the offence committed under which section of the IPC is not compoundable under section 320 of CRPC, that is section 320 of the CRPC. My dear friends, you all know that the compoundable offences has been discussed under section 320, and now we need to identify which offence is not compoundable under 320, and the right answer is here section 353 of the IPC. So that is the right answer here. Now come to the next question. That is the question is here, that is the object of proceeding under section 145 of IPC is toward of danger of breach of peace and not to determine the title. It was observed in which of the case? So under section 145, it is about the maintenance of the peace, not to determine the title. That means a land dispute is here. So now what is the right answer is here? The right answer is here Union of India versus Aji Bensanian Khatun. This is the case in which the court has discussed about this one. Now another question, in which case the presence of accused may be dispensed with at the time of delivering the judgment. So the options which are given here, when the personal attendance of the accused has already been dispensed with, and second, when the judgment is that of acquittal, the third is in both A and B above, and the last is that is none of the above. So in both the situation A and B, it is a possibility that the presence of accused can be dispensed. So this is the right answer, that is C here. Okay. The another question which had been asked in UPAPO 2006 prelims from the CRPC, in the interest of justice, a magistrate has the power to try a summon case as a warrant case, wherein the offence to be tried there under is punishable, and which under is punishable, which the imprisonment is there. So the right answer is here. That is the kind of the question which had been asked. That is the exceeding 6 months. So you can see here. This is the right answer to this question here. Now come to this another question, that is the of CRPC. In every criminal trial, when the magistrate finds the accused guilty, he shall pass the sentence after hearing the accused. So what would be the right answer to this question? So in that case, when magistrate finds the accused as guilty, he shall pass the sentence after hearing the accused. So whether it is a wrong, it is not required in summon cases. Yes, this is the right answer here. You can see it. So in summon cases, because the offences are very of small number of having imprisonment, so in that cases it can be a possibility. Now come to the next question which had been asked in the UPAPO Prelims 2006 here, and that is the procedure for trial before a court of session is provided in the following section of the CRPC. So the procedure for trial before a court of session. So court of session, what kind of the sections are given here? And the right answer to this question is section 225 to 237. My dear friend, this is also a very important question for the prelims. Most of the time the questions are coming from the session trials, warrant trials, summon trials, that from what section to what section they are having the section for these trials. So you can see it, you can see this. The another question which had been asked from the 2006 paper that we are discussing here, which of the following statements is not correct under the CRPC? So we need to identify the incorrect statement here. Okay, so that is means incorrect. You know, while attempting the question, you should underline, because sometimes we confuse between the correct or incorrect question had been, whether they are asking about the correct or incorrect. Sometimes this kind of the problem may happen. So it is better to have a underline. Okay. Now the answer is here. That is the first. That is where a private person or an authorized person has a right to arrest a person and hand him over to the custody of police. Such private person can also make search of the such arrested person. This is not possible. So the right answer is here. That is the correct answer is here. That is the, it is not possible for the a private person. Okay. The other question which is here, that is under section 125 of the CRPC, a magistrate has the power, the option is here, the magistrate has the power to grant interim maintenance and the expenses of the proceeding. The second option is here, has the power to grant so in this case, the magistrate has the power to grant interim maintenance and expenses of the proceeding here. So that is the way you can find this. The other question which had been asked in the UPAPO 2006 prelims from the CRPC, where any judge or magistrate is personally interested in a case, he shall neither try nor commit for trial such case, nor shall hear any appeal in such case, provided. And the right answer in this case is here, that is prior permission of its appellate court has been obtained. So yes, so in this case what will happen, section 479 of the CRPC will help you, because in that case where any judge or magistrate is personally interested in a case, then he shall neither try or commit for trial such case, nor he shall hear any case without the prior permission of any appellate court. Yes, because there would be a case of the biasness here. So section 479 of the CRPC is going to answer this to this question here. The another question which had been asked, in which of the following cases it was held that the provisions of chapter 8 and of the CRPC being in public interest are not violative of article 19 of the Constitution. And the right answer is here. It is about the case when very famous no member of parliament, that is Madhu Lime versus SDM Monghar. So that is the case in which the court had said that this chapter 8 of the CRPC is not violative of article 19 of the Constitution of India, and that is the thing. Another question which had been asked from the CRPC, that by Criminal Procedure Amendment Act 2005 in section 459 of the CRPC, the word less than 10 rupees have been substituted by the words less than 500, less than 50 rupees, less than 100 rupees, and less than 250 rupees. So the right answer is here, that is the A, less than 500 rupees. Okay. The other question which had been asked from the CRPC in 2006 for UPAPO, when there is a dispute between two courts relating to exercise of jurisdiction in a criminal matter and said courts are under subordination of different high courts, the matter shall be decided under section 186 of the CRPC by the. So the options which are given here, just go to the options here, you will see the options are these. A, that is the Supreme Court. The other option, that is the High Court of the larger state, High Court having more judges, High Court within more within whose area the proceeding first commenced. And the right answer is here, that is the D. Okay. So where the first proceeding has been started, commenced, then in that case, that High Court will have. Now, the other question from CRPC, that period of limitation for an offence punishable with a term of 2 years as per section 468 of the CRPC is 6 months, 1 year, 2 years, and the 3 years. So the right answer is here, that is 3 years. So that is the right answer. The another question which had been asked from CRPC, the power of the magistrate to detain a person for the purposes of police investigation is for a maximum period of, that is the 90 days. So the section 167 of the CRPC will help you here. The another question which had been asked from the UPAPO 2006 of CRPC, on refusal by any witness to answer a question or to produce a document upon being asked for, he may be sentenced to imprisonment for a period of 30 days, 7 days, 14 days, and 1 month. And the right answer is here, that is about the 7 days. So he can be imprisonment for 7 days here. The another question which had been asked, according to which section of the Police Act of police officer may be deployed in any part of the district. And now this is a question which is going to come from the Police Act of 1861. So the options which are given here, the options we are going to see, that is the A. Now let's start the question from the Police Act 1861 here. According to which section of the Police Act 1861, a police officer may be deployed in any part of the district. So which section is here? Section 20, 22, 21, 23. So yes, the option is section 22. By virtue of section 22 of the Police Act, a person of police officer can be deployed in any part of the district. The other question which is here, that is under paragraph of 169 of the UP Police Regulation. It is the duty of the police prosecutor to bring to the notice of the magistrate concerned all cases in which unclaimed property has been lying in Malkhana for more than. So the answer is here, that is 6 months. So that is the right answer. So under the paragraph of 169 of UP Police Regulation, it is the duty of the police prosecutor to bring to the notice within more than 6 months to the magistrate if it is a property which is unclaimed more than the 6 months. Then in that case, the police officer has to mention before all these things to the public prosecutor, and then the public prosecutor will bring all these things to the magistrate. Now, the paragraph 140 of UP Police Regulation requires that when a police officer sends a person for an examination by a medical officer, then what are the options is here? Then in that case, we are not going to discuss all these options here. We will mainly go to the right answer in this case, in this question. That is, he should clearly explain the object of the such examination. So whenever the police officer they send a person for examination by a medical officer, then he should clearly explain to the accused person that what is the purpose of this examination. The another question which had been asked from the UP Police Act regulation as well, that what type of officers is a reserve inspector in the reserve line according to UP Police regulation. And the options which are given here, that a general officer, officer in charge, deputy chief officer, or none of the above. And the right answer is here, that is the officer in charge. The next questions which has been asked, that is the section 7 of the Police Act 1861 deals with the following. So section 7 of the Police Act deals with the departmental proceedings. So this is the right answer. I am not going to discuss all these options here. Which of the following statement is incorrect regarding history seats? So the following statement which is incorrect, that is the option is here A. History seats of class B is for a period of 3 years and it need not be started. So a class of B period of 3 years need not to be started. It is incorrect, and the rest of the statement like these, they are the very much correct here. Okay. Next, go to the next question here. That is which had been asked in the UPAPO 2006. I'm a little bit fast because we need to cover 150 questions so that you can do a revision in well time. So if I will go for more explanation, then it will take more time to you to go for the revision. Therefore, I'm taking the pace which I'm using here for this question paper is little bit fast here. Okay. However, I'm trying my best to explain meanwhile something. Okay, don't waste not wasting much time. Just go to the question here. When it shall appear that any unlawful assembly or riot or disturbance have taken place and police officer is not sufficient for preservation of peace, a special police officer may be appointed by whom? He may be appointed by the magistrate on the application of police officer not below the rank of inspector. So this is the right answer here. The another question which had been asked from UP Police Regulation, and it is which chapter of UP Police Regulation deals with mounted police? And the right answer is here, that is chapter 8. It deals with the mounted police or mounted police. The another question which is here, which of the following is not correct statement regarding case diary? So the options which are given here, that is at which he received the information on which he acts, at which he begins investigation, at which investigation is closed, when he was called by the superintendent of police for inquiry regarding the progress of investigation. So this is not the correct option and statement. So the move to the next question which had been asked. The question is here, under the Police Act 1861, the word police includes such persons who have under the act been enrolled, trained, appointed, and selected. And the answer to this question here, that means police includes under this question, that is the enrolled. So a person is a police when he is a enrolled one. Enrolled. Okay. So another question which had been asked, which paras of UP Police Regulation deals with the post-mortem examination and procedure? And that is very important question here. That is which para talks about this. And the right answer is here, the para number 139 of the UP Police Regulation deals with the post-mortem examination and the procedure. Another question which had been asked here, from the Police Act of 1861, in which of the following decision it was laid down that the departmental proceeding can also be initiated against a police officer who has been held guilty under section 29 of the Police Act of 1861. And the right answer of this question is here, that is the state of UP versus Harish Chandra Singh. In this case, it has been stated, that it has been said by the court, that the person against a police officer against whom a guilty found, then he can a departmental proceeding can be started. Okay. Then the next question is based on the matching list 1 and list 2, and the list 1 talks about the surrender of the certificate of the police officer, deployment of additional police officer at rail and other works, village of police officers, a regulation of police, public assemblies and processions, and the list 2 is talking about having some sections here. Section 21, Section 8, Section 14. So A is basically belong to Section 2. B belongs to here, that is to the Section 14, and C belongs to, that village police officer belongs to Section 21, and D belongs to Section 30. So the right answer is here, that is 2413. So this is the right answer, 2413. Okay. Come to the next. The public prosecutor shall maintain the headquarter or register for the whole district containing the names only of those absconding officers. Okay, so the public prosecutor will maintain that kind of the register who are triable in the district court. So only for those people who are triable in the district courts, for them the public prosecutor will maintain a register here. The another question which had been asked from the UPAPO 2006, which I am going to take here, that is the UP Police Act here. That is the question. Just yes. So that is the question number 112 here. In which of the following decision it was laid down that the accused cannot use the case diary, neither the accused nor his counsel can requisition the case diary, and they cannot claim to go through it. So which is the case? And the right answer is here, Mukund Lal versus Union of India. This is a case where the court had said that neither the accused nor his counsel can requisition the case diary, and they can't claim to go through it. So this is the right answer. So all these questions which we had discussed, these all the questions were from the Police Act and the UP Police Regulation as well. Now we are moving towards the next part of this question paper, that is the questions from the Indian Evidence Act. So the question which we are going to start here from the Indian Evidence Acts are, so the first question which was here from the UPAPO 2006, the object of Indian Evidence Act 1872 as set out in the preamble is to define and amend the law of evidence, to consolidate, define and amend the law of evidence. So this is the right answer. You all know that because it is very popular, one of the questions. So the basic purpose of the Indian Evidence Act to consolidate, define and amend the law of evidence here. The another question which had been asked in the UPAPO 2006 from the Indian Evidence Act, when a number of documents are all made by one uniform process, as in the case of printing, lithography or photography, each is whether secondary or primary. So yes, of course, it is a primary evidence when everything is happening in the uniform process, as in the case of printing, lithography or photography. So each copies will be a part of the primary evidence. So that is the right answer here. Moving towards the next questions based on assertion and reasons. So assertion is here, in criminal cases for fact that accused is of good character is relevant. In criminal cases, bad character of the accused is always irrelevant. So what you see, you go to this one, what you will see that in the case of always it is not irrelevant in the criminal cases, and therefore the answer is here, that is A is true but R is a false one. Okay. Next question is here from the Indian Evidence Act. A marriage was solemnized in general customary form. What is the rule for proving that it is a legal wedlock? So how to prove this one? So for that, the options which are given here, that is the custom shall be proved by the evidence. The court takes judicial notice of the custom. The court shall evaluate the effect of custom on general public, and the last is all of the above. So of course the court will take the judicial notice of the custom according to which the marriage took place. So this is the right answer here. That is the next question which is here. The next question which is here, which one of the following sections of the Indian Evidence Act contain provision regarding cross-examination of witness to character? So this is the question, and the right answer is here, it is about section 140 of the Indian Evidence Act. The next question which had been asked in the Indian Evidence Act, a confession made by an accused person is relevant if it has proceeded from a person in authority unless made in the immediate presence of the magistrate. The B option is here. If it is made to a police officer unless made in the immediate presence of the magistrate. The third option which is here, that is the if it is made to a magistrate provided the police officer is present. The last option which is here, if it is made whilst he is in custody of police officer and is made in the immediate presence of a magistrate. So this is the right answer here of this question here. Okay. Now come to the moving towards the next questions. That is the evidence unearthed by the sniffing dogs falls under which kind of the evidences. Okay, because it is about the sniffing dogs, the dogs which are doing no smell and all these things, their kind of the evidence will come within the category of the scientific evidence. And here you can take the help of section 45 of the Indian Evidence Act. The another question which had been asked from the Indian Evidence Act, that is the question is whether A commits a crime at Kolkata on a certain day. Answer to this question, which of the following fact is relevant? So the fact which is relevant, that is A was out that day at Mumbai. So that is the very important, because he will take a plea of LV, and therefore you can find the answer to this question under the section 11 of the Indian Evidence Act. This is very popular question, and sometimes the mains in the mains paper they are also asking question about the plea of alibi. So that is the way you can see here. The next question which had been asked, moving towards the next question, whenever it is directed by the Indian Evidence Act, whenever it is directed by the Indian Evidence Act that the court shall presume a fact, it shall regard such fact as whether proved unless and until it is disproved, approved unless until it is disproved, or may call for proof of it. The last is the third one is that is proved, and the last one is proved and shall not allow evidence to be given for the purpose of disproving it. Yes, once it shall, then it means proved unless until someone is not going to disprove this one. So this is the right answer, and you can see the section 4 of the Indian Evidence Act where you can get the answer to this question here. The next question is, who among us the following is an accomplice? My dear friend, just remember last year's question when I was doing a kind of practice of the 2002 is the answer is here, that is a prostitute is not an accomplice. Is an accomplice. Sorry to this. Who among us is the following is an accomplice? Yes, the answer is here, the prostitute. So just this is an important questions which sometimes the people are asking in the interviews as well. So be careful about that, because prostitute is a person who is indulged in that kind of action here. Okay. The 1, 2, 3 question number 1, 2, 3, which you can see on the screen here. Relevancy and admissibility under the Indian Evidence Act are where they are synonymous, coexisting, neither synonymous or not coexisting. So yes, because both has been defined differently and they are very much different to each other, so they are not coextensive and not synonymous to each other. Okay. Come to the next question, that is A sues B for trespass on his land. B alleges the existence of a public right of way over the land which A denies. The existence of a decree in favor of defendant in suit by A against C for a trespass on the same land in which C alleged the existence of the same right of way. So whether that would be a relevant one. So if you just go to the options which are given here, A is saying relevant, but it will not operate as estoppel. Irrelevant, C says as a conclusive proof. But the right answer is here D, that is relevant but not a conclusive proof that the right of the way exists. Okay. The next question which had been asked in the UPAPO from the Indian Evidence Act, that is the examination after the cross-examination of a witness by the party who has called him is called which kind of the examination? So that is, you all know that it is one of the very popular question for prelims, and sometimes the questions are also have been asked in the mains as well, and the right answer is here re-examination. Now come to this question number 1 to 6. of this UPAPO Prelims of 2006 question paper, that is from the Indian Evidence Act. Evidence of custom cannot be given to establish. So whether in which cases the evidence of custom cannot be given for the to establish something, and the answers which are here, that is about the criminal right, okay, because it is a very absurd kind of the rights which you can claim. So civil right, for inventory right, for customary rights, you can have evidence of custom, but for the criminal right there is no such evidence of custom can be produced before the court. The next question which has been asked, the object of cross-examination is, so what is the basic object? The option A is to examine the intelligence of the witness, to examine the impartiality of the witness, to examine the credibility of the witness, to examine the good character of the witness. And the right answer to this question is here, to examine the impartiality of the witness. Okay. The next question which had been asked, A accused of murder alleged that by grave and sudden provocation he was deprived of the power of self-control. B denies this fact. So what would be the right answer to this question here? The burden of proof upon whom will lies. So the burden of proof must be shared by both A and B. The burden of proof is on B. The burden of proof is on prosecution. The burden of proof is on A, because A is a person having this. So therefore the burden of proof will be on the A here. Okay. So next question is here, because he has to prove that he was not having self-control. So he has to prove. So burden of proof will be on the A. The next question from the Indian Evidence Act, the father of accused did not support the prosecution during the trial that he told the witness that his son, that means accused, had committed the murder. The statement of the witness should be in the nature of secondary, hearsay, hearsay, or none of the above. The right answer here, that is the hearsay evidence. Okay. Another question from the Indian Evidence Act, a dying declaration. See, this is another paper of UPAPO of 2006. In the last year, there were also questions from the dying declaration. So you can see the portions are very clear that from which portions the questions are going to be asked in the prelims and also in the mains examination. Okay, and that is the answer which is going to be based on the code. Okay, so a dying declaration cannot form the sole basis of conviction unless corroborated. Is a weak kind of evidence. It stands on same footing as any other piece of evidence, has to be subject to a very close scrutiny for reliability. And now the answers which are given here, it is based on the code here. And now just go to the code, and the right answer to this here, that is 3 and 4. So the 3 and 4 is the right answer because it stands on the same footing as other piece of evidence and has to be subject to a very close scrutiny for reliability, because no, it is a case of a dying declaration, that person cannot be come again. Therefore, you need to be very careful for this statement. Okay. Now, next question is here. A wife had only seen a speeding vehicle which had crossed the husband from a little distance. She had not seen that accident herself. The husband died of heart attack a day later. Can wife's evidence be taken of what the injured husband said to her after the accident? So this is another question which had been asked from the here. So the answer here, yes, it is being a part of res geste, because it is part of same transactions. Therefore, in that case, he can do this. Okay, so wife can do, she can do this. Okay. The other question, that is of 132 question number. If the digital signature of any subscriber is alleged to have been affixed to an electronic record, the fact that such digital signature is the digital signature of the subscriber must be proved except in the case of. So it is to be proved except in the case of secure digital signature. Okay. So this is the right answer here. And section 85B of the Indian Evidence Act having the answer to this question here. The other question which had been asked, and that is the question number 133 of the UPAPO Prelims 2006. The question between A and B is whether a certain deed is or is not forged. A affirms that it is genuine, B that it is forged. So what kind of the options is going to be correct here? So whether A may prove a statement by B what that by B that the deed is genuine, and B may prove a statement by A that the deed is false. Yes, this kind of statement can be made here. So just go to section 21 of the Indian Evidence Act. You will be able to get the answer to this question here. Okay, because it is about the admission. Okay, so if they have made any kind of these statements, it can be taken into account against each other. Okay, now moving towards this next question, the man who had disappeared and remained unheard for 7 years by those who would have naturally been heard of him, and if he was alive, if he was alive, the presumption then arises that he is dead. What shall be the presumption as to time of death of such person? Yes, this is a question from section 108 of the Indian Evidence Act. You all know that because it is very popular section. And the answer is yes, C. Those who allege that the death should be taken to have occurred at a particular time will have to prove that fact. Okay, so that is the way you can see here. Come to the next question here. In a prosecution for rape where sexual intercourse by the accused is proved and the woman states in her evidence before the court that she did not consent. So what will happen in that case? So whether the court will presume her consent or not? Yes, the court may presume that she did not consent. Yes, this is the right answer to this question here. Okay, come to the next questions. Confession can be result of self-talk. Communication of confession to another person is not necessary. Was held in the case of which case? And this is very one of the popular case, and that is the case of Sahu versus state of UP. So in this case, it can't be proved against that person who has made the confession. The another question which is here, that is the question is here, an approver's evidence, the person who's giving approving any of the fact or like that, the options is here, must be reliable, must be corroborated, must be reliable and preferably corroborated, is not admissible. And the option which are here based on the code, that is the 1 and 4, 3 and 2, 2 and 4, and 1 and 2. And the right answer is here, that is it must be reliable and it must be corroborated, and then therefore in that case it is can be taken into account. So the option B is correct here. Okay, next, moving towards next question. Principle of vicarious liability was first time decided in which of the case? And the options which are given here, that is the R versus Huggins, R versus Stephenson, R versus Tolson, R versus Prince, and the right answer is here R versus Huggins. So this is the right answer here. Come to the next question. Which one of the following sets correctly identifies the specific defenses available in action for defamation? Okay, and that is the options which are given, that is privilege, truth, fair comment, mistake, privilege, C, fair comment, mistake, truth, D, mistake, privilege, truth, and the right option is A, and it is about privilege, truth, fair, and comments. So these questions were from the Indian Evidence Act. Now there are certain 10 questions or more, 11 questions or more from the Indian Penal Code, which we will cover in the next part of this video. So just stay tuned. We are moving towards the next part of this video here immediately. So the rest question from the UPAPO 2006 are belonging to Indian Penal Code. Let's start the questions from the IPC here. Question number 140 of the UPAPO Prelims exam of 2006. It says like this. Some provisions of the IPC have been amended by the Administrative Tribunal Act of 1985, Administration and Arbitration and Reconciliation Act of 1996, Information Technology Act of 2000, and none of the above. So the right answer is here, that is IT Act of 2000. Some provision of the IPC have been amended because of the IT Act. Okay. Come to the next question of the IPC from the UPAPO 2006. Which of the following is a leading case on the intoxication? Very popular case, and I think You all know the answer to this question. That is Director Public Prosecution versus Baird. So this is the right answer here. Moving towards the next question based on the match list and list 2. List 1 is having some of name of the offences. List 2 is having the provisions of the IPC, dowry death, housebreaking, assault, wrongful confinement, section 340 of the IPC, section 351 of IPC, section 304B of the IPC, section 445 of the IPCs. So these are the sections. So let's see the codes which are given here. So if you see the dowry death, it belongs to 304B. On the other side, the housebreaking belongs to section 445 of the IPC, and then come to the assault, it belongs to the section 351 of the IPC, and the wrongful confinement belongs to the section 345 of the IPC. So the right answer to this question would be C, 3421. Okay. Moving towards the next questions, under which of the following sections of the IPCs there is a provision of death sentences? So now the answer is going to give through the codes. So the first is section 194 and 449, section 132 to 194, section 364A to 396, section 124A to 132. So these are the some codes are given, options are given. Now the codes are here. That is the 2, and the answer is 2 and 3, because section 132 and 194 there is a provision for the death sentence of the IPC here. Moving towards the next here, that is, which one of the following is not punishable under the Indian Penal Code? And the question is, options are here: preparation to wage war against the state, preparation to commit murder, preparation to commit dacoity, and then the kind of preparation to commit depredation on the territory of a friendly power. And the right answer is here to preparation to commit murder. It is not punishable under the Indian Penal Code here. Okay. Now moving towards the next question, that is a question number 145, which had been asked in the UPAPO Prelims of 2006. Which one of the following is an inchoate crime which is not completed? So you all know that criminal attempt is a kind of the crime which is inchoate, because yet the crime is yet to be completed, so it is incomplete crime. The another question which had been here: which of the following statement is not true? And the options which are given here: rioting and affray have been defined in section 146 and 159 of the IPC respectively, and then rioting must be committed in public places, affray may be committed in the place, in any place, like that. So the right answer to this question is here, that is the rioting must be committed in public places, affray may be committed in the any place. So therefore what you see, it is not a true statement. Okay, just be careful, it is not a true statement. Okay. Moving towards the next question, that is the question number 147 here. The offense of thefts become robbery when the offense of thefts becomes a robbery, and the options are here: committed by 5 or more persons, committed by 2 or more persons but less than 5 persons, coupled with the force, coupled with imminent danger to life. So that is the case which you can see here. In this case, a theft is going to become a robbery when this situation is going to be made. Okay. Now moving towards the question number 148, and the third last question: deception is an essential element of the following, and the options are here: criminal, breach of trust, forgery, cheating. Yes, in all these above cases there is a deception. You need to not go for deception, then in that case this kind of the crime will happen. The last two questions, question number 149: A, by putting B in fear of grievous hurt, dishonestly induces B to sign in a blank paper and delivers it to A. B, after signing the paper, delivers it to A. A has committed what kind of the offenses? So it is a case of the extortion. Okay. So that is the way you can see, because it is in fear of grievous hurt. So there is a fear also of the hurt and grievous hurt here. The next question which is here, and the last one of this UPAPO Prelims of 2006. Which of the following is not an essential element of unlawful assemblies? So 5 or more%, yes, it is a part of this one. Then common object, yes, it is a part of this the unlawful assembly. And the fourth one is that is to resist the execution of any lawful of any legal process here. And the answer which is here, the third option, that is the common intention is. That is a common object here. So the right answer is here common intention here. The right answer is here the common intention. Okay. So it is not an essential part of the unlawful assembly. So with all this, we are finishing here the questions which had been asked from the law subject here in the UPAPO. My dear friend, this would be a very fruitful session for all of you, and I hope that you are liking this one. Please share this video to much of your friends so that they can also get the benefits. However, in the competition, you all know that there is also some kind of competition, and sometimes the people are not sharing the videos. But this is a part of the competition in student life. I hope you will share all these things, and I hope you will like this one. Please subscribe this channel so that you can get more videos on the preparation, because this video will not help only for UPAPO. It will also help you in the UP Judiciary and also in other states examination like the MP and the Rajasthan as well. So thank you to everyone for watching this video. Please subscribe, and we will meet you to the next video in the UP APO revision series. Thank you to everyone.